Welcome to the Compliance Counsel on Command webinar series. Today's topic is the CFPB's loss mitigation and delinquent borrower servicing rules. I'm Jeff Anderson, an attorney at Dickinson Law focused on regulatory compliance for community banks. The rules we'll talk about today, the early intervention, continuity of contact, loss mitigation, and also the policy and procedures rule, are all in Regulation X under the umbrella of RESPA. They all use the federally related mortgage term as opposed to dwelling. That means that the application of these rules is going to be limited to federally related mortgages. And the key thing to keep in mind there is to be a federally related mortgage, it has to be attached to real property. So under Regulation Z, those provisions can apply to boats and RVs and motor homes. Here, these delinquent borrower rules are under Reg X. They'll only apply to those mortgages that pertain to actual real property. They're also limited to a borrower's principal residence. So these won't apply to those second homes or vacation homes. Another key thing to keep in mind, everything we talk about in this presentation is limited to large servicers. So small servicers will be exempt from everything except for this slide. Small servicers are not exempt from the foreclosure limitation. That limitation is you cannot make a first filing for any foreclosure unless the mortgage is more than 120 days delinquent. There's no exception to that. There's really not any nuance to that. It's just a hard and fast rule. Loan has to be at least 120 days delinquent before you can file for foreclosure. The second piece, if you have a borrower that's performing under a loss mitigation agreement with you, you can't foreclose on them. You can't file for foreclosure. That should seem like common sense to all of you out there. If you have an agreement with somebody and they're performing under that agreement, of course you shouldn't be able to foreclose on them. That's one of those pieces in regulations where it seems to be common sense to me, and it seems to me it should already be prohibited under just general contract law. But apparently somebody out there was doing it because they issued a regulation on it. Now, everything else we'll talk about, small servicers will be exempt from. First rule is the policy and procedures rule. Your non-small servicers are required to have detailed loan servicing policies and procedures. That pertains to how they deal with delinquent borrowers, how they handle loss mitigation options, how you provide information in a timely manner when it's requested, when you get information or error notice requests, oversight of service providers that deal with your loan servicing. So you likely already have a vendor management policy. Now you need to ensure that either you have a freestanding policy or a part of that vendor management policy that specifically addresses servicing vendors. Policies and procedures on facilitating information transfers during servicing transfers, and also on how you provide to borrowers your procedures on error notices and information requests. So if you're not a small servicer, you need to provide that borrower with your procedures on error notices. How does the borrower submit error notices to you? You need to notify them of that. A big part of the policies and procedures is ensuring that you can compile a complete and accurate servicing file within 5 days. That includes any credits and debits, the security interest, notes or communications with the borrower, and copies of any documents that relate to loss mitigation or error notices submitted by the borrower. So you small services out there that are exempt from this policy and procedure requirement, that doesn't necessarily mean that you shouldn't have policies and procedures on these items. Examiners may come in and you could get written up for not having a policy on error resolution notices, for example, particularly if they find that you've had some compliance misses. Once they find misses, they may say, well, you need a policy and procedure on this. It just means you're exempt from the explicit requirement in the regulation and all the detail that's required in this regulation on these policies and procedures. The delinquent borrower servicing rules are in 39, 40, and 41. The first is early intervention. And the first piece of that, you have to make a good faith effort to establish live contact by the 36th day of the borrower's delinquency. What does live contact mean? That means a live telephone call or an in-person meeting. It can't be a recording. It has to be live personal contact. What does a good faith effort mean? A good faith effort can be a combination of many things. It could be sending a letter, sending an email, leaving a message. Any of those could be part of a good faith effort to establish live contact. Now, how many times do you have to attempt for it to be good faith? Clearly more than one. So just sending one letter that requests the borrower to call your contact isn't going to be good enough. But it could, arguably, it's a very subjective, but it could be sending a letter and following up with a phone call and leaving a message. That could be a good faith effort. Once you get to multiples beyond two, I think if you're documenting that, you should pretty clearly be in that good faith effort range. After you've made that good faith effort to establish live contact, by the 45th day of the delinquency, you're required to provide a written notice. And there are model forms for that written notice. So let's back out of this and I'll show you what the model form looks like. This is the model form for early intervention notices. It's not really highly formatted. It's more of model content. This can be sent on your letterhead. It can really follow whatever format that you deem appropriate. But you have to address these three elements. One, you have to have this statement encouraging the borrower to contact you and providing information about loss mitigation options. We'll talk in the next slide about who you put in the address here, whose name and address you put in there for them to contact. That gets into the continuity of contact rule. The second major piece, you have to list out and provide some general descriptions about the loss mitigation options that you offer. It doesn't need to go into great detail, and it doesn't need to be specific to that borrower. You may not know at the time this letter is sent out what loss mitigation options that they qualify for. You only need to provide them with a general description of the loss mitigation options that you offer at your bank. The third major piece is that reference to the housing counselor contact information. You provide the website and the telephone number of the HUD housing counselors. That notice is provided by the 45th day of delinquency. Continuity of contact. This is the name and address that you're going to provide on that notice. You're required to assign personnel to a delinquent borrower to deal with their delinquency, to answer any questions they have, and to help them if they apply for a loss mitigation option. Assigning personnel doesn't mean it needs to be one person. You can assign a staff of individuals to delinquent borrowers at large. You just need to ensure that everyone on that staff is prepared to communicate with delinquent borrowers and has access to the account and all other communications that that delinquent borrower has had with that personnel. The purpose of this is really to address the runaround that some borrowers were receiving in servicing of their loan. And all of you have likely experienced this at some point, be it on a cell phone or through a credit card, where you call one day, you talk to Jimmy, and you talk to Jimmy, you think your problem's resolved. But then 2 days later, you find out, hey, this problem's still out there. You call again, you talk to Susie. Susie has no idea what you talked to Jimmy about. She has no access to any of that information. That's what this continuity of contact is trying to address at a high level. Of course, that was never an issue at your bank. You're a community bank. Jimmy and Susie at your bank communicate with each other and everybody's on the same page. But as with a lot of these mortgage rules, the problem, although not caused by community banks, the solution to that problem expands further out than the problem, and it flows down to some community banks, particularly those that are not small servicers in this area. The third piece is the loss mitigation procedures. Nothing in this rule requires you to offer loss mitigation options. You don't have to offer loss mitigation at all. But if you do, there are certain procedures you need to follow. After you get that loss mitigation application from the borrower, there's certain timing and expected responses. What is a loss mitigation option and a loss mitigation app? A loss mit option is any alternative to foreclosure that you offer, and an application can be any oral or written request for a loss mitigation option that you get from the borrower that's accompanied by the information that is required by you to evaluate that option. That definition of loss mit application is very broad and open-ended. You can define what information you require. So it's not like the definition of application for purposes of providing a GFE, where once you receive certain information, it triggers the disclosure requirement. Here it's up to you. You can define what information you require to evaluate a loss mitigation application, but once you get that information, it triggers the timing in this rule. The loss mitigation timing in this rule is very circuitous. The regulation is very difficult to navigate and read. What I've tried to do on these next few slides is break it down in a way that is hopefully a little bit more understandable and easy to digest. Essentially, the requirements for the timing and the communication requirements after you've received a loss mitigation application depend on how far away you are from the foreclosure sale. The closer you get in time to the foreclosure sale, more requirements start to drop off. So we'll start with 90 or more days prior to the foreclosure sale, or if a foreclosure sale hasn't even been scheduled yet. If you're 90 or more days out, or one hasn't been scheduled and you don't have a date, you have to acknowledge receipt of that loss mitigation application within 5 days. Within 30 days, you have to evaluate the application and respond in writing. If you choose to offer a loss mitigation option, you have to give the borrower 14 days to accept or reject that option. If you deny that loss mitigation application, you have to give the borrower the right to appeal that denial to independent bank staff. This is a wholly new concept in regulation. You essentially have to have your own little appellate court within your loss mitigation department. You'll have some staff that reviews the initial loss mitigation application. When they choose to deny it, now the borrower gets the opportunity to appeal that denial within 7 days, and it has to be heard by somebody else, somebody independent from that staff that heard that reviewed the initial application. Now we get within 90 days of the foreclosure sale. So once you're 89 to 40 days prior to that scheduled foreclosure sale, you still have to acknowledge receipt within 5 days. You still have to evaluate and respond in writing within 30 days. But now that right to appeal drops off. So if you deny it, they don't have a right to appeal anymore. Also, if you give them a loss mitigation offer, the timing is reduced in which they're given to respond. Instead of 14 days, now the borrower gets 7 days to accept or reject that loss mitigation option. Now we get within 45 days, 37 to 44 days prior to the foreclosure sale, you get a loss mitigation application. Now there's no requirement to acknowledge receipt. You just have to evaluate and respond within 30 days, and you still have to give that borrower 7 days to accept or reject the loss mitigation option. Again, the right to appeal is also out the window at this point. Now you get to within 37 days of foreclosure. 36 days or closer to the foreclosure sale. Now the whole regulation drops off. Now the CFPB says you're so close to the foreclosure that if you receive a loss mitigation application that close, you're not required to evaluate it or respond within any timing. You still can at your option, but you're not required to. The regulation doesn't apply. Hopefully those slides on the loss mitigation application were helpful. To me, that regulation is one of the more difficult ones to navigate with these new rules, which frankly is saying something because a lot of them are pretty difficult to navigate. But that's one that I had the hardest time anyway figuring out. So hopefully that was helpful, and that concludes this presentation. Thank you all for listening.